Welcome back to Quick Bits, your Monday dive into all the legal goings on. Today we need to talk about Disney's ill-advised arbitration, the new trials that may be pending for Scott Peterson and Alec Murdaugh, plus everything that's going on in the Girardi trial, and arrests, some pleas, and a lot of information in connection to the death of Matthew Perry. So with all of that, we should probably just get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. First off, talking about Scott Peterson, I have broken down his bid for discovery in connection to a new trial. That'll be linked down below. In fact, all of the content that I mentioned today will be linked down below if you want the deeper dive content for today's topics. But I've seen more conversation around Scott Peterson now that there are competing docuseries, and of course there have been lots of conversation about this case, but the LA Innocence Project took this case on to ask for discovery, possibly in a bid for a new trial for Scott Peterson. The court largely denied that bid, but granted DNA testing as to one item of evidence, a piece of duct tape found on Laci Peterson when she was recovered. The DNA testing of that duct tape was ordered in late July. Those results will be filed with the court under seal, and then we will start to see maybe that motion for new trial based on the discovery of whatever that DNA says. Of course, if nothing comes back that can be the basis for a motion for new trial, then we might not see much going forward from here. But I am keeping an eye on what's going on that case, just to see where this latest discovery bid gets us, if anywhere. But in a more successful bid for a new trial, Alec Murdaugh has some interesting updates that, of course, I will be breaking down more fully. The big win for Alec Murdaugh comes from the Supreme Court granting direct hearing of his appeal. This is in relation to his motion for new trial that was denied by Justice Tol after hearing from all 12 jurors on the Murdaugh case. When I broke that down, we talked a lot about the difference in standards between South Carolina and recent U.S. Supreme Court decisions. So it doesn't surprise me that the South Carolina Supreme Court is taking up this matter to determine whether or not the standard that is applied by case law in South Carolina needs to be reevaluated. If the standard is reevaluated, it is very good news for Murdaugh. Under the standard that the defense is pushing for, it seems much more likely that he will be successful in his bid for new trial. So that split in the law sets it up where the Supreme Court said, you know what, instead of this wandering through the Court of Appeals and then getting to the Supreme Court, we are going to take this on directly. And Justice Tol, a former Supreme Court justice in South Carolina, was very clear in making her record that this record is being made so that the appellate court has all of the information that they need, and her determination that the standard in the state of South Carolina, a standard which requires the defendant to show prejudice, is the standard that the courts at the current time intend, but legal jurisprudence changes only when there is a case. The issue must be ripe. So there has to be a question that the courts can take up, and that's exactly what's happening here. There is a ripe question of law for the courts to take up and determine whether or not the actions of Becky Hill and the potential impact on the jurors is determined under the more favorable to the defense Supreme Court standard federally, or whether South Carolina is going to keep the standard that requires the defendant in this circumstance to show that the jurors were impacted and that they were prejudiced, versus not having to show that because it's implied. So a very interesting split in authority of the law, and that is the reason I think that the Supreme Court has decided to directly take this up. It is the exact type of question that Supreme Courts want to resolve. Does the jurisprudence in South Carolina need to shift? And if they decide yes, that puts Murdaugh on track potentially for a new trial to be granted based on Becky Hill's interference with the jury in this case. Either way, it's a reminder why we need to hear from jurors as I continue with you to wait for a ruling in the Karen Read matter with regard to whether we will hear from those jurors. And speaking of a jury trial, that's exactly what it seems that Disney is trying to avoid in some of the most un-Disney BS we've ever seen. I'm sure you've heard about this story, and even when I was in Boston at the rooftop pool party with Mix 104.1 and Carson and Kennedy, I got to talk not only to some of the new kids, but also to a lot of the law nerds. And this was the story that y'all were asking me about in addition to the Karen Read trial. This Disney story is wild. A gentleman named Jeffrey Piccolo has sued Disney for wrongful death based on the death of his wife, a former NYU doctor who has a severe nut and dairy allergy. They were eating at Disney World in the Raglan Road Irish pub, something that they found because of all the great reports about how that particular restaurant handled allergies. I've handled food allergies with Disney on behalf of myself, on behalf of friends, and they have always been incredibly mindful. You often have chefs coming out to talk you through what you can and can't eat if it's a buffet, etc. I have rarely had a Disney experience where one of the chefs hasn't come out and I've been like, no, I can see that the pasta with tomato sauce has tomato in it. I'm fine. I just need to make sure that when stuff comes, you don't put salsa on top of it or whatever it is. But they generally send out a chef to walk you through what on the menu can be modified, what can't be. So I was really surprised to not only hear that that had not been done in this case, but that the allergy exposure at that restaurant caused the death of Dr. Tanguson, which her surviving spouse is now suing over. And not only did Disney not say, let's settle this case, this is horrific and should never happen, but Disney said in court filings in June that the family signing up for a free trial of Disney Plus meant that their arbitration clause in that massive thing that people scroll through and hit accept, that the arbitration clause in there means that they cannot get a jury trial and must go to arbitration over the wrongful death lawsuit. That is a wild and I think abusive use of those types of terms of service and terms and conditions. I'm going to be breaking that down more because we've seen other lawsuits where companies have tried to do this and it has failed spectacularly, as I think it should here. The Disney Plus agreement should just encompass your use of Disney Plus. If you have an issue with Disney Plus, it will limit your use or your losses to the amount you're paying in the contract, but that doesn't extend and shouldn't extend to potential negligence or claims of negligence at a park. Like if you can't access Disney Plus, you can say, hey, Disney, can you refund me my last 3 months? And if they fight with you, you can go to arbitration over it that they would normally pay for under those types of adhesion contracts. But to say that somebody who had a free subscription of Disney Plus signed away an arbitration agreement to be able to ever bring a negligence-based lawsuit for something that happened in the park is wild. But of course, Disney is also arguing that the purchasing of tickets to the park forces arbitration. So it is really a two-part argument. If you'd like me to break down more of what Disney is saying, let me know. Because when we're looking at the ticketing to the park, we are more in the situation we've seen in Astroworld and other cases where they're saying that the agreements made when you purchase a ticket are holding you. But the lawyers that chose to also argue that Disney Plus was the arbitration agreement that was binding are wild. How did the PR team at Disney ever let this pass? And how did the more senior attorneys ever think that this was not going to A, get out, and B, was going to work? Because it's ridiculous. So we'll see. But if you want me to break down more about the ticketing into the parks and whether or not that might have some legal import, let me know in the comments. And things that are already in trial. The Girardi case was back in court last week and will resume on Monday, August 19th. And I think we'll wrap up. And I would be surprised if there wasn't a jury verdict this week, depending on when the jury gets the case. but it seems that there are only a few witnesses left, and the defense called one of their witnesses out of order, which means that witness was probably not available later on in this week of trial. And so the defense witness testified while the prosecution witnesses were still testifying and before the prosecution had rested. That's not really an unusual thing to happen, especially with expert witnesses like the doctor that testified. So last week, not only was there heartbreaking testimony from one of Girardi's clients who was brought in by another attorney in the case, Erica Saldana, testified about the accident that injured her son, and her son ultimately passed from the severe and serious life-altering injuries sustained in that accident, which, based on those in court, not only brought tears to the witness, but to others in court as well. And Erica testified about the fight with Tom Girardi to try to get the settlement money for her son's accident, which was supposed to cover her being able to get a new house that could accommodate his wheelchair and the medical needs and ongoing medical needs so that they could be full-time caregivers for their son after this accident, a settlement that she was entitled to and was never paid out. The jury also heard from the attorney that brought Erica Saldana's case to Tom Girardi and asked Girardi for help on the case, and that not only was that attorney fighting with Girardi over the settlement money for his client, but also his own legal fees, talking about how Girardi went to hand him a check for part of the legal fees and settlement, but it wasn't signed. And when he asked Girardi to sign the check, Girardi lost his mind on him and started screaming at him, and then took the check back and said, "There's bills to pay." Girardi also told him, interesting to me, that he couldn't pay the legal fees and settlement because he was waiting on loans. We know from the bankruptcy that Tom Girardi was using legal lenders to stopgap some of these things, and those lenders weren't getting paid and continued floating the Girardi Keese law firm. I've got a bunch of smoke for that, but I cover it in my longer form content. But what's a giant red flag about this from a legal standpoint is loans should never be involved in paying out a settlement fee, because the money comes in and it is dedicated to that client, or should be. It should go into a trust account, the attorney's fees and the costs come out, and then it gets distributed to the client. It shouldn't go anywhere else, and you shouldn't need a loan because you have the money that goes to the client. It's wild to me what Girardi was doing with this law firm, and we've seen this over and over again in the bankruptcy filings and the other fights with the Lion Air case, the civil lawsuits, and more. The jury also heard from IRS agent Ryan Robertson, who testified about the money that was moving around from Girardi Keese, $20 million from Girardi Keese that went to Erica Girardi's company, EJ Global, and money traced to jewelry and cars and the lavish lifestyle with the private jets. Do you remember Erica Girardi joking on Real Housewives about whether or not they should take the big private jet or the small private jet? This is why they wanted jurors that had never seen the show. But we also heard about the cars that Girardi was funneling money to, valued over $5 million for those vehicles. Then the defense called their doctor out of order. This is the doctor who evaluated Tom in 2021 after Tom started claiming that he couldn't have defrauded people because he didn't have the intent. He didn't know what was happening with money. He didn't know what was going on. So with fraud, there has to be an intent to defraud. And the defense is trying to build an argument that this was all a whoopsie because Tom Girardi's mental state was declining. But the doctor for the defense was focusing on from 2017 forward. The thefts charged in this case date back to 2010. And there's not going to be a lot of explanation between 2010 and 2017. But for my Bravo fans out there, you're going to remember why 2017 is so important, because in 2017, Tom Girardi had that car accident that was disclosed late on Real Housewives. When Erica was on the show in 2017, this was never discussed. This came up much later, after the house of cards was crumbling. And I have to wonder now if it came up on the show after Tom determined that he might use mental decline as a defense to benefit him, knowing Tom has known since 2020 that Judge Durkin in Illinois forwarded this case for federal prosecution. He knew that this was going to come up. He knew that the feds were looking into this. And I suspect he knew enough of what he had done to start trying to figure out what his defense was going to be. That's my opinion. So on the show, we start seeing discussions from Erica of this 2017 car accident and that there was a decline after that, and she never wanted to talk about it on the show. And you start to see the doctor saying, yes, the MRI from the car crash showed that he did have some brain tissue loss in the frontal lobe and hippocampus, and that could have impacted some of the executive functioning and other things. And I just kind of laughed in ADHD, and I'm like, executive functioning? Tell me more about that again. But there were emails back and forth with assistants and other attorneys saying that they were frustrated that Tom had to be reminded to pay clients. I don't know if that necessarily shows what the defense wants to show, that Tom doesn't know what's going on, or if you look at the frustration of the other lawyers saying clients aren't getting paid, that it shows that this is happening on a very large scale when it's taken in connection with the testimony of clients and lawyers saying that they were fighting with Tom about getting paid, and that money never should have been going out of those client settlements. And he was treating his law firm like a Ponzi scheme. New money comes in and it pays old debts, so people will stop getting up his ass about it. It's appalling. And finally, after a quick word from our QuickBit sponsor, we need to talk about what's going on with the prosecution surrounding the death of Matthew Perry. Thank you to today's QuickBit sponsor, Lume. If you are trying to get in those last-minute trips in the month of August, I applaud you. My kids have head back to school, but that doesn't mean I am not sweating like I'm on vacation. But humidity is a real thing, and I want to make sure when I run into the law nerds in person and give all of the big hugs that the thing I am not worried about is my BO. And Lume is a whole body deodorant, so you can use it wherever without a worry. If you are ready to try it out for yourself, Lume's starter pack is perfect for new customers. It comes with a solid stick deodorant, a cream tube deodorant, and 2 free products of your choice, like the mini body wash or deodorant wipes. And then you get a body wash that helps control odor, the wipes for when you need it on the go, and then the stick and cream tube deodorant for whatever bits and pieces need it. And plus you get free shipping. New customers get 15% off all Lume products. And if you combine that with the 15% discount on the starter pack, you are getting over 40% off of the starter pack. So use our exclusive code EDBQB to get 15% off your first purchase at lumedeodorant.com. That's code EDBQB, like the Quick Bits, at LumeDeodorant.com. Trust me, it is going to keep you fresh. Let's get back to today's episode. On Thursday, August 15th, as I was stuck in an airport leaving Boston, the U.S. Attorney's Office held a press conference and announced that 5 defendants had been arrested and charged in connection with the death of Friends actor Matthew Perry's fatal fentanyl overdose. Remember, Matthew Perry passed away October 28th, 2023. He was found unresponsive at home in his hot tub, and it was later released from the coroner's department in Los Angeles that his death was caused by the acute effects of ketamine and included numerous contributing factors, but one of those was drowning because he was in the hot tub. What was interesting about this death, and it was speculated at the time about whether this was an overdose, but law enforcement responding to the home didn't find the things near Matthew Perry that you would often see in an overdose where somebody had taken narcotics and then passed away. You would normally see that still in the area. Nothing was found at the home, and now we have a lot more clarity as to why. One of the individuals arrested was his in-home assistant, who is charged with and has pled to distributing the ketamine that killed Perry because he was injecting Perry at Perry's home. So his assistant has been charged and pled guilty. This is very common in Fed cases where you will see multiple defendants, some who have already taken deals. There are 3 defendants in this case who have already taken deals and pled guilty. That includes the in-home personal assistant of Matthew Perry, a middleman who was distributing ketamine, a doctor who was taking the ketamine out of his own ketamine clinic and helping it be distributed, 2 who have not yet pled and are facing numerous charges in a sweeping 18-count indictment, who is now being referred to as the ketamine queen because in the indictment, that is the AKA, and Dr. P, again, because in the indictment, that is the AKA, the ketamine queen of North Hollywood, Dr. P of Santa Monica. Those individuals have been charged in the superseding indictment and arrested. They have not taken deals. The others will be, of course, building that case against them. And from the press conference, it seems that there are more charges and more defendants to come based on a sweeping investigation into what law enforcement called a widespread underground drug ring. Some of the charges in this 34-page indictment are distribution of ketamine resulting in death, possession with intent to distribute of methamphetamine and others, possession with intent to distribute methamphetamine and ketamine, maintaining a drug-involved premises, and other charges. There's quite a lot of information in that indictment and subsequent documents that I am going to be getting into more this week. But these are unusual circumstances where you see doctors charge from the resultant death of something that can be used either in a illicit or a medical capacity. We saw this with Michael Jackson. We also saw this in the death of Anna Nicole Smith. So this is not unusual to the U.S. attorneys, and this is not something that is unusual to prosecuting cases in Los Angeles, where you do have a high density population of celebrities and the wealthy that have private doctors that are prescribing them things outside of typical medical use. It took a while for the feds to bring these charges, but as the feds do, they tend to make sure that their case is ready to go before anyone is charged. And it seems when looking at the background of this case that that's exactly what happened here. And this is not the last we will hear about it. I would be surprised, though, just looking at this indictment, if this case goes to trial. I will not be surprised if we see more individuals charged based on the amount of digital devices the feds took in their initial raids in this case. And with that, hopefully that gets you up to speed in the latest of the cases that I'm following. There is lots coming up on the docket this week as well, so make sure you have the Law Nerd app. It is a free app to keep you in the loop with everything I'm covering on live streams and on the Quick Bits podcast and the Emily Show, which you can find on your favorite podcast player or on the Quick Bits YouTube channel and the Emily D. Baker YouTube channel. We are getting ready for Corey Richin's preliminary hearing. There is going to be more filings in the Koberger case. I'm still waiting to see the defense reply in the Hannah Gutierrez Reed case. There will be more filings soon in the Murdaugh case to the Supreme Court. So we have quite a lot to cover. So thank you for being here. Thank you for being a Law Nerd. This is the Quick Bits, and I will see you soon. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.